It is exactly 7:45, and of course, we have him on the line. Good morning, Mlungisi. How are you?
Morning, Sharif. How are you and your listeners?
Well, I can speak for myself and I say I'm fabulous, thank you. It is not as cold as it's been the last couple of days, so I'm quite happy. You're well?
No, I'm good. I'm happy to hear what you're fine. Are you living in an area where there's no shitting what?
Well, you know what? We keep our fingers crossed and we pray on a daily basis that they skip us because we've had so many issues when it comes to load shedding. So it's been quite a dilemma. We've been struggling, but we're hoping that they skip us for a little while. We have many spots within Eldorado Park that is still struggling with load shedding. So. Yeah, it's a problem. But thank you yet again, Mr Mthembu, the Senior Registrar in the Motions Court for the Gauteng Division of the High Court, Johannesburg, for joining us and for talking to us about a conversation that is very difficult to have because not many people actually want to give us the information because it is, this is information that is privy to the court processes and so forth. And today, of course, we're talking about obtaining information on cases at the High Court. Now, first and foremost, who do we then speak to? That is the most important thing for me. Who do I go to if I need information with regards to a case that is being heard in the High Court?
Okay, thanks, Joyce. I'm going to request that we try and break the conversation into subcategories insofar as where the information is and what type of information it may be.
All right.
We're going to speak about the archives. We're going to speak about transcription. We will then get into general inquiries, media access to court hearings, and basic access to one's active court file. Okay. Now with the archives, the country as a whole have got, I will say, a proper archiving system. We even have a national archive center. Where all the information is stored. I assume from all departments, be it the Home Affairs, be it the Health Department. Same applies with documents from all the courts. They are stored in the National Archive Center. And in terms of what type of documentation will you find there, you'll find anything that is up to 1980. Okay. So any document that may have been processed by the court before 1980, you will definitely find from the Archive Center.
All right.
Then anything between 1981 to 2005 is stored on the off-site facility, and the request for anything between those years could be strictly made with an individual in the department. I've got an email here. I'm not sure if you'll be able to capture it, but it is tsambo@judiciary.org.za.
tsambo@judiciary.co.za.
.org.za.
Okay.
That's correct, yes. And for anything between 2006 to March 22, we still have it here in the physical court building on site in our archives offices by the 10th floor. And a request for any document between those years, you can simply make by sending an email to jhbfiles@judiciary.org.za.
jhbfiles@judiciary.org.za.
That is correct, yes.
Okay.
And in so far as who may request and what may be requested, it all depends on who is requesting.
Okay.
For a file that you are a litigant, say you're an applicant or you're a respondent, you're entitled to request for anything that may be on that file, but obviously for a specific usage. For an example, in normal course, the request that will come across is those of court orders. To say, I lost a court order, I need to have it so as I can go to that department and process whatever. In the normal course, that's what they will request. But anything that is in the file, so long as it has not been ordered by court as classified, may be requested. And the classification, remember, is not out of the court's direct decision. It's going to be based on applications by both the parties to the litigation to say document 1 and 2 may not be made public because of reasons that those parties will advance before the court.
Okay.
But in the general course and scheme of things, you hardly have such. In the general course, anything that is on the court file is assumed to be of public record. However, there is specific applications like a surrogate applications that we hardly ever even see ourselves as registrars. They only go through the judge and the decision is made and order is made and they are sealed and locked in a safe place and mostly in a safe, like a proper safe. Yeah. Maybe you can ask me a question.
Well, now, how does the public then request to go about obtaining documents or information on cases from the court?
Okay. Remember, I had asked that we break the discussion into different subcategories.
Yes. So we can answer them according to those subcategories, Mlungisi.
Not a problem. So if, say, for an example, you are a litigant and you want a record, an entire record of your case, more especially in criminal cases, this is where this happens. A case was heard, it was dealt with, you were not happy with the findings by the court, so you were given a couple of years to spend in jail and whatever. You now need to appeal to the Supreme Court of Appeal in Bloemfontein, and you want the entire court transcript of that record.
Yes.
However, with you wanting that, you can't really afford to pay it yourself.
Okay.
What normally happens is independent transcription service providers will do the transcription service of that record.
Okay.
However, for persons that are saying, no, I don't have the money to pay for that independent service, there is a process where they can make a direct request to the registrar through the office of the chief registrar for a consideration of that transcription being undertaken on a state cost. Okay.
Okay.
And they think that application must be accompanied by, including you proving that you don't have an income and you are not owning assets that may be greatly valuable. And we will then consider the application, and if it is successful, we'll proceed to do the transcription for you.
Okay.
And if not, should we decline, you have the right to go to court for an order. However, still you need to prove why must that transcription be done on the state's cost. Okay. And on the other hand, you've got inquiries that are general, however, on items that are on the file. For an example, you say, I need to know when the matter is going to be in court, or rather, I need to know if my attorney has filed 1 and 2, whatever the case might be. Remember, from when we started, we did advise that we've got different sections within the court.
Yes.
So, in line with the directive that was issued by the Judge President on the 11th of June last year, we've got query escalation platforms for all the sections, meaning each office has its method of how you may escalate a query in relation to whatever as a process in that office or anything that may be on the file which is with that office. Okay? So out of the same process, you could then make a query. In terms of the directive that I just mentioned of, it's in paragraph 241 of the directive, meaning you could just simply go and quickly try to get the revised directive is issued by the Judge President. It's dated 11 June. And they, 241 covers both Pretoria High Court and Johannesburg High Court in terms of how you query with those different sections involved. Then we said as well we're going to speak to the issue of media access to court hearings. Yes. There, it's mainly, the driving point is, you will know, public interest. Any method that is of public interest, media personalities are required to make a request with the judge presiding over the matter through communicating with the judge secretary to say, look, we want to be present in court for this matter, and in all likelihood we may want to have it broadcasted and whatever. They bring an application in the form of an email, making motivations properly so, and then the judge will decide if that submission warrants that he makes an order that media is given access. But in most cases, even before the matter sits, we would know that it's of public interest, and judges will not easily dismiss any request for publication of such matters.
What
Then,
many instances,
yes.
just a quick question, Mlungisi, with that one, would it then be, let's say for instance, it's public interest, it's a murder case of a young person, and the judge feels that he will not allow media. Is there any way that that media house can then appeal for access to a case such as that?
That is correct. They can. However, with the specific question of a victim being a minor,
Yes.
in the general cause, we do not, all court processes, even back at the merge court, do not allow for anything that exposes the minor's details to the public. Even if there is no media application, it's not publicized, the details of that victim are always kept in confidence and are not easily made available to whoever that may have an interest. To a point that minors hardly ever come to court to give evidence. They do give evidence in camera. And in most instances, it's through being assisted by a social worker or whatever, insofar as making that environment suitable for them. But they hardly ever get exposed to court. Now, say, for an example, your question was drilling down to the issue of we need to have the details for the purpose of publication, taking aside what I've just said, that they hardly ever make those details available, and including the testimony of that particular victim. In such an instance, an application is made, yes, a judge may refuse, and yes, an appeal may be made.
All right. And then, of course, in that instance, and I'm referring to a specific case at the moment, which is the Nathaniel Julies case. In many instances, when we did get to the courthouse, we were told that there was, we weren't all allowed as media houses and media people to actually go into the courtroom. Is that also part of the stipulations that we need to adhere to?
Without giving a specific answer on the question, like I said earlier on, an application is made and a decision is made. It starts and it ends there. Safe to say, you've got that right of appealing that decision.
All right. Now, Mlungisi, when it comes to receiving documentation or information from a courthouse, in particular the High Court, we've gotten who we should contact. But now it happens that I don't have access to email, that kind of thing. If I get to the High Court, where do I go? Who do I speak to that will be able to assist me on a face-to-face type of basis in order for me to get access to the information that I require?
Okay, perfect. Remember, we also were to cover access to one's active court file. I think let's fit that question under there. I'll try and not be long about it. Currently, all active court files are on the online system that is referenced as Case Line, soon to be known as Court Online. Meaning all active cases are no longer on physical hard files. They are on the online system. Now, to directly answer your question, within the court building, we've got a general office. It's 008. It has just been upgraded to become the court online help desk. So with any direct interaction when you come to the court, the security personnel are most likely to direct you to the 008 office. And from there, an assessment will be made of where exactly is your file in terms of which court. Is it the is it the motion section? Is it the trial section? Is it the appeals, or whatever the case might be? With that understanding, you may make a specific request for yourself to be registered on the system where your file is, basically to create an online profile, out of which they will proceed to assist you with how, after the creation, you may log in and be able to access whatever that may be on that file, including then being able to open the file, go through the file with you, and making you see what type of documentation is currently on the file. Okay. And where warranted and sufficiently motivated, you may say, I need that document, and they can print it out for you.
Okay. All right.
So basically, it's with 008, and obviously with other section like my section, the motion section.
Motion section, yeah.
If you do come in, we will not say no. Go to the general office for them to assist you. Should we have enough motivation from you by proving that yes, you are the litigant in the matter, and yes, there is a document that you want from there, and you are directly entitled to it, we could easily get it printed for you without any problem, so to speak.
Okay. That sounds fairly easy. That sounds very user-friendly, Mlungisi.
Now, most definitely, we are trying to make all the systems beneficial to the stakeholders, and especially to the litigants.
Wonderful. Is there anything that we haven't covered that we need to maybe cover?
I think we'll leave it for the next installment. However, around this question, I don't think there's anything.
Okay, great stuff. Mlungisi Mthembu, thank you so much for your time. Thank you for speaking to us. We will then, of course, speak to you on the 19th.
Not a problem, Sherry. Thank you very much for the opportunity. I think the department is appreciating this engagement a lot.
Well, we appreciate it as well because it's quite important information that you're sharing with us. And it also just helps our listeners understand exactly what it is and what the processes are when it comes to the High Court. So we appreciate you. Thank you so much.
We thank you as well. Bye.
Take care. Bye-bye.